Item number 43, first appeal है admission. Land acquisition matter है lordship.
Admit कर तो भी और बताइए.
In the meantime, lordship, respondent may be directed to sign note discuss the compulsion. This is a land acquisition matter, lordship. Any date may be fixed, lordship. Finally.
Judgment कब कर दें? ये बताइए. ऐसे they may not disburse, ऐसा नहीं होता इस तरह से order. ठीक है? रुक जाइए. Admit. Issue notice to the respondent number 2. State of Jharkhand.
State को हमको copy कर देते हैं.
The counsel for the appellant is directed to serve notice upon the respondent number 1 by serving memo of appeal along with its enclosure to the office of learned Advocate General and file the receipt thereof. Call for the records from the consent court. कहाँ का है ये?
रांची के अंदर.
To concern police station रहेगा. On number 2. For which request is filed by Tuesday.
In the meantime, lordship, otherwise.
इसीलिए रुक जाइए. इसीलिए इतना पुलिस स्टेशन को खोज रहे.
नहीं, कुछ observation
नहीं, ऐसा नहीं, ऐसा observation इस तरह से blanket observation.
पैसा चले जाएगा तो फिर
ऐसा कैसे चला जाएगा? आपके रहते किसी का पैसा चला जाएगा? ऐसा हुआ है आज तक? कौन सी केसों नहीं लगेगा? आपके रहते आपके लिटिगेंट का पैसा चला जा सकता है? आइए भी नहीं फाइल किया ऐसा ऑब्जर्वेशन. तो कॉस्ट अब हम आप कॉस्ट करेंगे.
नहीं, जजमेंट कैन नॉट बी स्टिल. Therefore, I am paying because
without any idea you are paying for it.
I have to file the
in a first appeal.
Yes. Lordship is rightly said.
Next to this the pension नहीं.
कर लीजिए. कहाँ है तो?
एक कंप्रोमाइज बोला था जो हम लोग का फर्स्ट अपील.
Item 44.
हो गया कॉम्प्रोमाइज.
अभी तो कोई टर्म एंड कंडीशन नहीं बताएगी सर. डेबिट सीरीज.
हाँ एक सेकंड. ये क्या है?
ये एडमिशन फर्स्ट अपील है. Item 44.
एडमिट नहीं हुआ अभी तक.
फर्स्ट एडमिशन.
मिस्टर सुधीर कुमार शर्मा वो है ही यहाँ पर. फॉर्मल एडमिशन के लिए आया है. Admit. Issue notice to the respondents for which requisites under speed post as well as through ordinary process be filed within a period of 4 weeks from today. Let a copy of this order be forwarded to the council for the appellant. Soft copy. ऐसे none लिखने का ही नहीं. 11 को नहीं हो पाएगा ना. 1 महीना तो उनको रिक्विजिट फाइल करना. Officer tracks speed post delivery. Post on 8th of August, 8th of September. 8 September में भी नहीं हो पाए. 7 September. 7th October. Sorry.
Item 45.
आपका है अनिल कुमार and दीपक कुमार. इसको भी एडमिट करिए. झारखंड. Issue notice to the respondents for which requisite under speed post and उसमें call for the records for which requisites under speed post and ordinary process be filed within a period of 1 month. Or same date. एक कॉम्प्रोमाइज वाला क्या हुआ आपका? क्या हुआ सर आपका कॉम्प्रोमाइज?
एक कैलकुलेशन की है 18% इंटरेस्ट के हिसाब से।
उनको दिखाइए ना कॉम्प्रोमाइज में हमको क्या देखना?
सर
हाँ सर बताइए उन हमको नहीं अभी देखना।
कॉम्प्रोमाइज तो कुछ हुआ नहीं।
अच्छा नहीं होगा तो चलो मेरिट पे सुनेंगे, हमें क्या जरूरत पड़ा कॉम्प्रोमाइज में करने का?
तो एक डेट फिक्स कर दिए।
हाँ
आज तो
डेट तो
कंप्रोमाइज
आज है।
नहीं, आज तो कंप्रोमाइज के लिए
अच्छा रुकिए ना वेट, कहीं जाना है?
जरूरी काम से जाना। हम रूल कोड से लीव लेके जा रहे हैं।
Counsel for the parties have submitted that the matter, the parties have not agreed to settle the matter out of court. With the consent of the parties, close this case on next Wednesday. आज Friday है ना?
जी
देखिए तो बैठ कोई भी डेट कौन सा फिक्स हम लोगों ने डेट
हम तो तैयार है कि जो हम पैसा दिए हैं हमको लौटा दे, इंटरेस्ट दे दे तो तैयार हैं।
4th August. आप अपना सिनॉप्सिस फाइल कर दिए हैं? आप इसमें कोई सिनॉप्सिस फाइल किए हैं अपना?
हम कर सकते हैं इसका, हम फाइल कर चुके ऑलरेडी फाइल में।
Counsel for the appellant undertakes to file synopsis of arguments and copy of the supporting judgment which he seeks to rewrite.
From date is for finals to item 1, second bit 4 to 3 of bit 1 3.
No, I have not forgotten anything. Now,
directly asking
you argue issue-wise. Issue-wise in the sense, the substantial question of law. So which substantial question of law?
First substantial question of law which is formulated on 19/7/2006. Whether the plaintiff can be held to be non-suited for not paying balance or agreed consideration amount within the stipulated time, though there is no finding of the court below that time for the essence of contract. But in suit for specific performance, there has to be a specific issue by the court below with respect to the readiness and willingness, as well as with respect to whether time was the essence of contract. But in this case, there was no such issue was ever formulated by the trial court or by the high court or by the appellate court.
Readiness and willingness is not the point in this
No,
case.
I'm just trying to answer you.
No, do not
Because
travel
we are-
beyond the substantial question of
Yes,
law.
ma'am.
You want to
No
say
such-
without any issue.
Yes. Without any issue with respect to whether time was the essence of contract. And therefore, there is no finding by the court with respect to essence of contract.
Just no such finding has been given. Okay, just a minute. So,
when there is no such finding of the essence of contract, my lord, therefore, my lord, the payment, the remaining consideration, although my lord, I have paid a substantial amount of consideration, which has now been admitted at the later period, my lord, it now been admitted, my lord, the substantial amount has been paid. My lord, that my lord, I can make payment subsequent also. I'm still ready because my lord, what I said, my lord, I in the
we are not on that, you just stick to the question.
Yes, my lord. My lord, it says, my lord, if whether the plaintiff can be held to be non-suited for paying, not paying balance of the agreed consideration within the stipulated time. My lord, the stipulated time was end to end, it has been given. Even if, my lord, I have not paid the substantial remaining consideration, my lord, whether, my lord, it can be considered to be non-suited. Now, my lord, I on the last occasion,
No, it is not a case of non-payment.
Yes, my lord.
The formulation is not on non-payment. The formulation is that the amount, if not made within the stipulated time.
Yes.
There is no question of law on non-payment.
Lord, I just simplified, Lord, whether the plaintiff can be denied the relief for not paying the balance consideration within that particular time. Lord, I have not paid. If Lordship is of the view, Lord, ignoring Exhibit 9, Lord, now it's beyond the purview of consideration, then I can maintain a suit for specific performance. What I can understand, Lord, from the question of law.
No, you are doing whatever you are thinking about.
Lord, I was only making submission, Lord, that even, my lord, the end-to-end date has been mentioned in the agreement, my lord, that does not make the agreement, my lord, as essence time as the essence of contract. Unless, my lord, there is specific condition for the purpose for which the agreement was executed. In the agreement, my lord, they are only
Just a moment.
sorry.
The same does not. Unless specific purpose is mentioned.
Yes.
Specific purpose in the sense.
Specific purpose in the sense of particular date for the my lord, in the here in this case, my lord, they have mentioned in para number 2 of the agreement that for the purpose of marriage of daughter, my lord, of the defendant number 1, they require this amount. My lord, no date has been mentioned when the date of the marriage has to be solemnized. In the absence of the same, my lord, the time cannot be held to be essence of contract. My lord, I made on the last occasion I gave an example. If a marriage has to be solemnized, my lord, a date has been fixed for marriage. If I have in order to deliver some flowers, my lord, if I tender beyond the date, my lord, then time is the essence of contract. If no date is fixed for the purpose for which the agreement is executed, then time is not the essence of contract. Here in this case, my lord, शादी लड़की की शादी के वास्ते सुबह सुबह बिक्री करने की इच्छा रखते हैं. So no date is mentioned. Therefore, time is not the essence of contract. We have to see the content, my lord, of the agreement, my lord, which says if it would have specifically mentioned the date, my lord, when the marriage is to be solemnized, then it would have the essence of contract. Having not done so, and moreover, my lord, the defendant has not come in the witness box to deny that if they have not received the remaining consideration also.
That is a separate thing
Yes.
altogether. उसमें आप अब देखिए remaining consideration payment के बारे में इसमें मत घुसिए क्योंकि इसका substantial question of law नहीं.
Exactly.
And there is a finding that the remaining consideration was not paid. So that is staring at you. So इसीलिए बार-बार remaining consideration में मत जाइए.
Exhibit 9 has been started. Yes.
Yes.
Lord, I would like to place one of the operating. My lord, lordship is well conversant with the fact, my lord. My lord, even my lord, I am still, my lord, if lordship permit, my lord, by virtue of this court, my lord, I will make the remaining consideration along with the penal charge if lordship permits, my lord, by virtue of this, my lord. Because, my lord, I have a specific statement that I am still ready and willing to purchase, my lord, the property. Because I am in the possession of the property as on date.
It is not your case that you are ready and willing to pay the balance consideration amount and buy the property. Mr. Sharma, we have admitted your case. We'll record your evidence. एक केस में Mr. Sharma वाला है.
But the
Yes.
plaintiff, my lord, para number 9, that the plaintiff has been still ready and willing to perform his part of contract, but the defendant number 1 refused to perform his part of contract.
Which part of contract you are ready and willing to perform as per the plaintiff? Which part of contract you are ready and willing to play
Lord,
perform as per the plaintiff?
Yes. As per the plaintiff, lord, because as on record, my lord, exhibit 9 is for 5,000 rupees only. Remaining, if any, my lord, I can pay payment of 5,000.
No, that is not the case.
Yes,
Your case's entire consideration stood paid
yes, my lord.
and you came in possession.
Yes,
But finding is that entire consideration has not been.
not in.
To which part of it? So that was not your case.
Lord, my case is, my lord, for the purchasing of stamp paper and all, I will
Yes.
ready and
So
willing,
that
my
is
lord,
to
Yes.
the extent of purchase of stamp
Yes.
paper or whatever.
whatever they, yes.
And one more thing, the property was sold.
Yes.
Is there any prayer to set aside the sale?
No.
There is no such prayer. But the purchaser is a party.
Yes. They have not filed any counter claim with the claiming the possession.
No,
From
there
their end.
is not a question of counterclaim. The property was sold,
Yes, my lord, it was sold.
right,
Hmm.
to the co-defendants,
Yes,
but no prayer was made to set aside the sale.
yes, yes,
But it was only a prayer that all of them should join.
yes. And for injunction, it has been prayed for. So, these are the only facts, my lord. I am not praying for cancellation of the deed, my lord. Rather, my lord, if they are joined as a defendant, my lord, they can execute a deed if allowed in my favor, in favor of the plaintiff, my lord. Along with defendant number 1. Yes, but there is not specific prayer to that aspect. Join as a plaintiff, as was read. After adjudication, a decree of specific performance of contract can pass in favor of the plaintiff, directing defendants jointly and severally to execute the sale deed in favor of the plaintiffs by way of specific performance of contract and failure to execute the process of.
Yes. First substantial question of law पर और क्या बोलूं?
Lord, you will place the authority, Lord, to stay.
Yes.
to-
Which all judgments you pass? I want to cite. First, give me the list, and then I will.
Lord, I have given.
Uh,
Lord, I'm citing.
you have given you cite each one.
Yeah, 1977 Supreme Court. 1005.
This is the only citation you are relying so far as substantial question of law number 1 is concerned.
No, there was also.
If there are others, you just give the list.
So there is one more word in this respect is AIR 1967 Supreme Court 868.
868.
Yes. And got one more word AIR 2022 Supreme Court 1793.
That's all.
Yes.
I mean, please.
But just 1977 Supreme Court was cited in last occasion also.
No, you cite it again.
Yes. But in my case, end-to-end date has been mentioned. I'm repeating again, the end-to-end date within which period I have to make payment. It was mentioned. But here in this case, exactly the similar set of facts. I'm reading the paragraph 5.
You see, let us see what was the issue which was involved.
read from paragraph number 1. But the issue is there, but it comes later on.
No, issue number 1 and trial court framed 2 issues. This is important.
Yes, it is.
One is on readiness and willingness, we are not concerned.
Yes.
Whether the contract did subsist on the date the suit was filed.
Yes. So this finding, my lord, trial in this R case, my lord, the trial there was specific point of limitation which is answered in my favor.
No, limitation is another thing. Subsistence of a contract is another thing. Limitation is execution of contract. Subsistence of contract. Suppose there is a contract and it is for a period of only 3 days. Whether the 3 days, maybe 3 days, whether the contract subsisted on the 4th day. That is not limitation. That is not limitation. Limitation is enforcement of a right.
Yes, enforcement of law.
That is not limitation. It's not one and the same.
Shall I read after the issues?
No, yes, read it, please. The trial court found
The trial court found that it was proved beyond shadows of any doubt that the appellant was always ready and willing to perform his part of contract, and respondents were not at all anxious to execute sale deed in his favor, and that the respondents were guilty of breach of contract. On issue number 3, it found that even though the time for getting the sale deed executed expired on 24th May 1964, the appellant would not be disentitled to the relief of specific performance of contract or sale on the ground that delay, as the respondent themselves were responsible for it. The respondent preferred an appeal before Allahabad High Court, and the bench of the court on argument set out 2 points for determination in the appeal. They are whether the appellant or the respondent committed breach of contract entered into between 24th March 1964 and whether the time was the essence of contract. If not, its effect. The High Court found that the respondents were always ready and willing to perform their part of contract in terms of agreement dated 24th March 1964, and it was the appellant who committed the breach of contract and not getting the sale deed executed by 25th May 1964 in terms of the agreement dated 24th March 1964. The High Court on the issue as to whether time was the essence of contract held that in circumstances of the case and in view of the conduct of the parties of serving on each other's notices, the counter notices and telegrams, they expressed their intention to treat time as the essence of contract, and once the time is held to be essence of contract, the appellant's suit for specific performance must pay. The High Court also held that even if the time is not held to be essence of contract, it was the opinion of the appellant that it is not entitled to degree for specific performance, as had been failed to perform that he was ready to perform his part of contract. The appellant applied for a certificate, and the High Court, by its order dated 22nd February 1971, granted a certificate under clause 7. In this appeal before us, the learned counsel for the appellant submitted that the High Court was in error in holding time was the essence of contract, and the High Court's finding that appellant was not ready and willing to perform his part of contract, while the respondents were always ready and willing to perform their part of contract, is opposed to the oral and documentary evidence and probabilities of the case. The first,
let us see here. The trial court held that the respondents were at breach. The appellate court held that the appellant were at breach. And therefore, the appellant argued before the Supreme Court that the court was in error in holding that time was the essence of contract, and that the appellant was in breach.
yes. Here in my case, when the agreement will not lapse,
ये आगे बढ़ते हैं जजमेंट को पहले समझना बहुत जरूरी है ठीक है you are relying or heavily relying upon this judgment so you better place it properly.
The first question that arises for the consideration is whether time is the essence of contract. In order to determine this question, it is necessary to set out the suit agreement, which is marked as Exhibit 23 at page 137 of the table. It runs as soon. Shall I read the element also?
No, we have read it, yes.
Yes, on point number 2 again. That you are taking us at present a sum of rupees 4,000 in cash as earnest money. The receipt thereof has been acknowledged by us. A revenue stamp at the foot of this letter, and that the remaining sum of rupees 20,000 shall be paid by you to us at the time of registration. Kindly mark registration. The expenses relating to registration cost stamps shall be borne by you and shall be entitled to get so and so. Paragraph number 4. Here's important again. You must get the sale deed executed within 2 months, that is on 24th May 1964. Date of registration is also mentioned. And in case you do not get the sale deed registered within 2 months, then the earnest money amounting to rupees 4,000 paid by you stand forfeited without serving any notice. But in case we are some way we evade the execution of sale deed, then you will be entitled to compel us to execute the sale deed legally and shall be liable to pay cost and damages incurred by you. That's why I'm reading the second column, the operative portion of the finding after the agreement. Shall the relevant clause of A is clause 4, which provides that the appellant must get the sale deed executed within 2 months, that is 24th May 1964, and in case the appellant did not get the sale deed registered within 2 months, then the earnest money amounting to rupees 4,000 paid by the appellant shall stand forfeited without serving any notice. The clause further provides that in case the respondent in some way evade execution of sale deed, then the appellant will be entitled to compel them to execute sale deed legally, and the respondent shall be liable to pay cost and damages incurred by the appellant. Here is important. It is settled law that the fixation of period within which the contract has to be performed does not make the speculation as to the time the essence of contract. When the contract relates to sale of immovable property, it will normally be presumed that time is not the essence of contract. Next page. It may also be mentioned that the language used in the agreement is not such as to indicate in unmistakable terms that time is the essence of contract. The intention to treat time as essence of contract may evidenced by circumstances which are sufficiently strong to displace the normal presumption that in a contract for sale of land, stipulation as to time is not the essence of contract. Shall I collaborate with this plot in our agreement?
We see your plain and written statement.
Sorry,
Plain and written statement.
Shall I read the agreement first?
Because
the agreement is genesis melody of the. Yes, also permit I can read the plain also. But you may take the para number 3 again.
No, not only para 3. You read the full text of it.
Yes, para number 1. And defendant number 1 being the absolute owner and having in possession of the land fully described in the schedule, entered into a written agreement duly signed and executed by him in favor of the plaintiff for a sale of scheduled land for a valuable consideration of rupees 27,500 on the terms and conditions laid down in the said agreement duly executed by defendant number 1 on 27/4/1997. The said land given in the schedule is below the suit land. Second, defendant number 1 agreed to sell the suit land to the plaintiff for a valuable consideration of 27,500, out of which the defendant number 1 received some of this 22,000 in advance, and it was further agreed that the formal sale deed would be executed within 3 months from the date of execution of the agreement on the receipt of the balance consideration amount of rupees 5,500 only. 3. That after the execution of the above agreement, the defendant number 1 delivered possession of the suit land to the plaintiff in token of proof of part performance of the contract by defendant number 1, and also the defendant number 1 received the balance money of rupees 5,500 on 15/5/1997 from the plaintiff in presence of witnesses tendered by the plaintiff. Fourth, that the plaintiff, after paying the balance consideration money of rupees 5,500 to the defendant number 1 on 15/5/1999, requested defendant number 1 to execute necessary sale deed, but defendant number 1 assured plaintiff that since the possession of the contracted land for the sale has already been given to the plaintiff, upon which the plaintiff has been coming in possession by all acts of possession, formal deed would be executed after some time. Fine.
So here you offered this 5,500 on 15/5/99. Well, after more than 2 years.
Already dated 8/5/1997.
No, your plaint, I'm reading your plaint.
Yes, but
Yes, रिट पिटिशन नहीं है, हम लोग कोई डेट कहीं से मिला के मैच मिक्स एंड मैच कर लेंगे. No. ये सब टाइपोग्राफिकल एरर सूट में नहीं चलता है. सूट में टाइपोग्राफिकल एरर को एमेंड करके रेक्टिफाई कराना पड़ता है. एवरी डेट इज इम्पोर्टेंट. इसलिए ये मत बोलिए कि टाइपोग्राफिकल.
15/5/1997, but your exhibit 9 says
Exhibit 9 में आप कहाँ जा रहे हैं? Exhibit 9 is not your document.
out of consideration.
But as per this,
It is 15.
remaining 5,500 was paid on 15/5/19.
Yes. Shall I proceed ahead?
Yeah.
5. That thereafter 3 months
Hmm.
for executing the deed expired and defendant number 1 did not execute. Version prohibited this. I have also mentioned that after the expiry of the deed. That thereafter 3 months time for executing sale deed expired and defendant number 1. Do not make. Can we flip to the previous page, point number 3, para number 3.
Yes.
But it's mentioned that received as balance amount of 5,500 on 15/5/1997. As a question about that. I'm sorry, but there is some mistake in this there. 5. Point number 5. That thereafter 3 months time for executing the deed of sale expired and defendant number 1 did not execute sale deed as required by law. The plaintiff several times requested defendant number 1 to execute the sale deed, but all requests went in vain, and the defendant number 1 always put off the matter on some or the other pretext by saying that the possession of the land has already been given to the plaintiff and therefore there remaining nothing to worry about the execution of sale deed. 6. That the plaintiff, after coming in possession of the suit land, plaintiff has amalgamated the suit land with his rayati land and made construction of his old house by extending over the suit land and also enclosed the entire suit land in one compound wall, including his rayati land and residential house, and using the usufruct therefrom. That the matter was going on peacefully on the assurance of defendant number 1, but suddenly the last week of October 1999, defendant number 1 started negotiation to the sale the land with defendant number 2 and 3. When it came to the knowledge of the plaintiff, he asked the defendant number 1 about the said negotiation and also informed defendant number 2 and 3 not to purchase the land for which defendant number 1 has no right title possession over the suit land, and also requested defendant number 1 on 1/11/1999 to execute sale deed in favor of the plaintiff immediately, but defendant number 1 refused to execute sale deed on 1/11/1999, and therefore plaintiff came to his lawyer and sent notice through him to this effect requesting him to execute sale deed for a suit land in favor of the plaintiff which came to the knowledge of the defendant on 3/11/1989, when the notice was drafted by his lawyer at Hindughat through clerk Shri Rameshwar Prasad, who was also scribe of the deed of agreement in question, and therefore defendant number 1 hurriedly executed deeds of sale of suit land in favor of defendant number 2 and 3 on 5/11/1999 at Hindughat registration office, and thereafter received the lawyer notice on 6/11/1999 sent by Mr. So and so. 8. Defendant number 1 having full knowledge, defendants having full knowledge that the defendant number 1 has already sold the suit land to plaintiff and in part performance of contract has delivered the possession of the suit land to the plaintiff, and plaintiff has been coming in possession of all acts of possession and notice through lawyer has been issued that defendant number 1 to execute two sale deeds.
What was the date of the notice?
The notice is dated after October 1989.
Date, अरे तो date होगा ना
yes.
notice का,
3/11/1999.
which came to the knowledge of the defendant.
Yes. Blood on 3, exhibit 3, that is exhibit also. 3/11/1999, which was served on 5/11/1999. And then
No, it was served on 6.
6 and 5/11 they executed sale. Page number 6. Defendant number 1 execute two sale deeds of the suit land in favor of defendant number 2 on 3 on 5/11/1999, which is not binding upon the plaintiff and is void and issue. That the plaintiff has been still and ready and willing to perform his part of contract, but defendant number 1 knowingly refused to perform his part of contract. That the plaintiff claims that the court will order the defendant specifically to perform the agreement by executing sale deed of the for the suit land in favor of plaintiff and accept physical possession of the plaintiff of suit land and pay the cost of the suit. The plaintiff has got an
That's right. Written statement. You all file common written statement.
Yes.
yes.
You place your written statement.
Yes. The suit is not maintainable in its present form. That the plaintiff has no cause of action for the suit, and the cause of action is stated in para 11 of the plaintiff rules and imaginary and has been made with a view to institute this false case. That the suit of the plaintiff is maliciously false and frivolous. Number 2. That the suit is barred by law of specific relief act. Also barred by that the suit is also barred by principles of waiver, acquiescence, and estoppel. That the suit is further barred by the law of contract act. That save and accept, which has been specifically admitted in view of the written statement, the other allegations of the plaintiff were deemed to have been denied by the that the statements and allegations made in para 1 of the plaintiff are not fully true and correct and hereby denied. It is true to the extent that defendant number 1, being absolute owner, was in possession over the lands described in Schedule A of the plaintiff, but it is totally false to say that defendant number 1 entered into the written agreement duly signed and executed by the defendant number 1 in favor of the plaintiff for selling of the Schedule A land for a valuable consideration of ₹27,500 on the terms and conditions laid down in the said alleged agreement, duly executed by the defendant number 1 on 29/4/97. That it is submitted and asserted that the defendant number 1 never entered into an agreement to sell the suit land in favor of plaintiff. The alleged date of agreement is forged and fabricated, and at the same time the purported and alleged signature of defendant 1 and the alleged date of agreement is also forged and fabricated. The defendant number 1 has never executed the alleged agreement, nor the defendant number 1 has put his signature over the same as alleged in para 10. That the statement and allegations made in para 2 of the plaintiff are not true and correct and hereby denied. It is totally false to say that the defendant number 1 agreed to sell the suit land to the plaintiff for valuable consideration of ₹27,500, and out of which the defendant number 1 received ₹22,000 in advance. And it was further agreed that formal sale will be executed within 3 months from the date of execution of said alleged agreement on receipts of alleged consideration amount of ₹5,500. Then the statement and allegations made in para 3 of the plaint are not true and correct and hereby denied. It is totally false to say that after execution of the aforesaid agreement, the defendant number 1 delivered the possession of the suit land to the plaintiff and in token of proof of part performance of the contract by the defendant number 1. And also the defendant number 1 received the balance money of rupees 500 from on 15/7/97 from the plaintiff in presence of the witnesses on tender by plaintiff. It is submitted here that plaintiff knowingly, deliberately and willingly does not give the names of any of such alleged witness. That the statements and allegations made in para 4 of the plaint are not true and correct and hereby denied. It is totally false to say that plaintiff, after paying the balance consideration money of rupees 50,000 to the defendant number 1 on 15/5/99, requested the defendant number 1 to execute the necessary deed of sale. But the defendant number 1 assured the plaintiff that since possession of the contract land for sale has already been given to the plaintiff, upon which plaintiff has been coming in possession by all acts of possession, the former deed will be executed after some time. 13. That the statement and allegations made in para 5 of the plaint are not true or correct and hereby denied. It is totally false to say that thereafter 3 months' time for execution of the sale deed expired and the defendant number 1 did not execute as required by law. The plaintiff several times requested the defendant number 1 to execute the sale deed, but all requests went in vain, and the defendant number 1 always spoke of the matter on some or other pretext by saying that possession of the land has already been given to the plaintiff, and therefore there remains nothing to worry about the execution of the sale deed. Page number 7, para 14. That the statements and allegations made in para 6 of the plaint are mischievously false and fabricated and hereby denied.
And so on, so it is complete denial.
Yes.
The agreement is also denied and everything.
Yes,
is
that
denied.
was the case in the report.
The terms and conditions of the agreement has not been even uttered
Yes.
in the plaint or the written statement,
uh,
right? So there was no occasion to frame an issue as to whether time was the essence of contract. The parties did not join issue on that.
yes.
The parties did not join issue on that. The issue was rightly not framed
Yes.
and rightly not decided.
Exactly. Because
Simple.
based on the pleadings,
Correct.
issues are settled.
Issues are settled based on pleadings. So agreement annexure se writ nahi chalega yaar.
But when once the trial court comes to the conclusion at the time of
So-
pronouncement of judgment on the basis of the pleader commissioner's report
No,
and the handwriting
you don't
expert
shift
report.
from the question of.
Yes. No, I am not shifting it. But what ought to have been formulated when the
No. What ought to have been done is not my subject matter. My subject matter is whether time was the essence of contract.
Yes.
Right? Now, since the pleadings did not refer to any such stipulation as to why the money was required, we will accept it that time was not the essence of contract because parties did not join issue on that. So you win on issue number 1. Then, yes, what do you have to say on issue number 1?
Yes.
Let us come back to issue number 1.
The issue number 1 is the question of law number 1.
Yes.
Whether the plaintiff can be held to be non-suited for not paying the balance of agreed consideration amount within stipulated time, though there is no findings of the court's claim that the time was essence of the contract. So now the question of law
Just a moment. The plaint said that the amount was to be paid within 3 months.
Yes.
They said that they paid the amount within 3 months. The 3 months expired and they approached you sometimes after 2 years in 1999 and then you refused to perform. Right?
That is there.
That is their specific case. But your case is of total denial,
Yes.
complete denial. The agreement itself is denied. Right? So it is not your case that time was the essence, I needed money for marriage, the marriage was to be performed, so therefore I did not go by the agreement, he did not pay the amount. Your case is of total denial.
Now in such background of the pleadings, and the pleadings and the facts which are on record. The agreement.
We are hearing him. वो तो आपको खाली written statement.
Yes.
So he should get a break. Yes.
But coming to the next judgment number, that is 1967.
1967.
Yes, ma'am. So, Tennessee resident. Second judgment, perhaps. I will read this serial number. But I would like to place some TIR 1967 Supreme Court, page number 868. But I would like to place from calendar 1. But we appeal with a special leave filed against the judgment of the High Court of Judicature of Madras, reversing the decree of subordinate judge so and so on original Supreme so and so. Mr. So and so and his son so and so hereafter referred collectively as appellant number 1 and 2, where the owners of the survey plot number so and so in March 1959, so and so son of the first appellant was standing trial in a criminal court for the offence of murder, and appellant number 5 was in need of funds to defeat him. On March 5, 1959, the appellant number 1 agreed 1 and 2 agreed verbally to sell survey number so and so to so and so respondents in this appeal for sum of rupees 15,106 and received rupees 1,006 in part payment of the price. No time was fixed for sale except Exhibit 1A was executed by the appellant number 1 and 2, reciting that the land was agreed to be sold by appellant number 1 and 2 to the respondent, and that and rupees 1,006 was received as an advance amount. On March 31, 1959, so and so was convicted of the offence of murder and sentenced to the imprisonment for life. On April 4, 1959, appellant number 1 and 2 received rupees 2,000 from the respondent and executed a writing stipulation that the sale deed will be executed on or before 15th of April 1959. But earlier was the oral agreement. It was recited in the writing that the appellant number 1 and 2 had agreed to sell on March 5, 1959 and received rupees 1,006 on that date and rupees 2,000 on April 4, 1959. And it was further recited that the appellant number 1 and 2 shall settle the aforesaid sale within 15th of April 1959 in favor of respondent. That amount shall be paid as per the particulars of the receipt of sale consideration. That even though the appellant number 1 and 2 are prepared to settle the sale accordingly, if the respondent raises any objection whatever to settle the sale, he shall lose the advance of this 3,006, and that even though the respondent is prepared to settle the sale, if the appellant number 1 and 2 raise an objection whatever to settle the sale, they shall add rupees 3,000 to the aforesaid advance amount of rupees 3,006 and pay in all a sum of rupees 6,006 to respondent. The agreement clearly incorporated a default clause imposing penalty upon party failing to carry out the terms of the contract, but the sale deed was not executed on or before 15th of April 1959. This was the second time the sale deed was not executed. The different reasons were given by the parties for not completing the sale by the sale stipulated. It was the case of the respondent that respondent number 1 and 2 wanted to consult a lawyer and to ascertain whether it was necessary to secure attestation of the first appellant's son and his daughter because the property originally belonged to the wife of the first appellant. It was the case of the appellant number 1 and 2 that it was full owner of the land agreed to be sold and that the children of the first were not interested in the sale, and the respondent set up a false excuse and neglected to take the sale deed as stipulated. On April 15, 1959, another agreement was executed. It was recited in the agreement As certain unforeseen circumstances have arisen to settle the sale on this date, as on being fixed as the terms are executed on 4th of April 1959 by us, three individuals have decided to consult a vakil so as to settle the sale within 30th of April 1959 and to settle the sale and to bind themselves as our condition mentioned in the previous agreement should whomsoever failed to finalize the sale. The sale was not completed even on 30th April 1959. Only on 30th April 1959, April number 1 addressed a letter to the respondent stating that agreement to sale was subject to specific undertaking. The time was the essence of the agreement and it was twice extended at the request of the respondent, and since the respondent has failed to carry out the agreement, even by 30th April 1959, the agreements were cancelled. The amount of rupees 3,006 paid by the respondent stands forfeited. Only on 30, this is important, which I read. On 31st July 1959, the applicant agreed to sell the land to Mr. So and so, who hereafter will refuse to refer to as April number 3. On August 1959, 3rd August 1959, the respondent deposited the balance of by him under the agreement of sale in a bank, and by letter dated 4th August 1959, informed April number 1 and 2 that time was not the essence and that he was ready and willing to carry out his part of contract, and respondent called upon the appellants in 1 and 2 execute sale deed within 3 days from the receipt of the letter against payment of the balance of the price. He offered to purchase the stamp paper and have the sale deed prepared for execution. 2. Reciprocal finding, directed to finding. That's the second column. Second column. 8 line. Second column. 8 line. The trial court accordingly rejected the claim of the respondent for specific performance, but awarded a concession made by the appellant number 1 and 2 to a decree for rupees 3,006 with the interest of rupees 6% from the date of the indicative realization of the appellant number 1 and 2. Against the decree, the respondent appealed to the High Court of Judicature at Madras. The High Court opined that the time was not the essence of contract, that delay on the part of the respondent is claiming completion of the sale on 30th April 1959 and on 30th July 1959 was not undue delay, and there was neither abandonment of contract nor waiver, and that even defaulting party was found as found by the trial court, the respondent was entitled to defer specific performance of the agreement to sell. The High Court accordingly reversed the decree of the trial court and decreed the claim of the respondent. Number 3. In this appeal, with specially 2 questions called for determination: whether under the agreement to sell time was the essence, and whether the appeal number 1, 2, and 3, the respondent was ready and willing to perform his part of contract, and what was the amount and disentangled for declared specific performance.
So where is the finding? Which pattern?
Yes, ma'am. The para number 5. The finding of the court with respect to essence of contract.
This is the finding of the trial court. What finding of
the consideration is being given by the
No,
court.
you just tell me what is the ratio of the judgment.
By-
You have seen the background.
I request that can be para number 5.
Paragraph.
Here is the finding. Here is the observation of the court.
This is trial court's observation.
No, it's not the possibility what is considering the findings of the trial court. The trial court relied upon 3 circumstances in support of its conclusion that time was the essence of contract for sale. Though no time was prescribed for the oral agreement in writing dated 4th April 1959 and 15th April 1959, there was a definite stipulation fixing a date for performance of the contract. Second, that the contract and the second and the third agreement contained a clause which imposed penalty for party guilty or default. Third, the appellant number 1 and 2 were in need of money, and it was to meet their pressing need that they were desired to effect the sale deed. But the agreement dated 4th of April and 15th of April do not express any unmistakable language that time was to be the essence and existence of default clause will not necessarily evidence such intention. Fixation of period within which the contract is to be performed does not make speculation as the time to be the essence of contract. Now we are going to the next page. First column, fourth line. First column, fourth line. This is the only final conclusion also. The intention, as Lakshmi got that fourth line, intention. Intention to make time essence of contract may be evidenced by either express stipulation or the circumstances which are sufficiently strong to displace the ordinary presumption that in a contract for sale stipulated as to the time are not the essence. In present case, there is no express situation. Some spelling mistake is there. Situation and the circumstances which are not as to indicate that it was the intention of the parties that time was intended to be the essence of contract. It is true that even if the time was not normally the essence, the applicant could be by notice served upon the respondent call upon to take conveyance within the time fixed and intimate that in the default of compliance, the requisition contract will be treated as cancelled. But here's the important thing. Not the respondent defendant should have given a notice that within the time has been not within the time that they have not paid to me. Not Supreme Court so and so, wherein the contract for sale of immovable property, time fixed for performance was not the essence of contract, but the vendor has been guilty of unnecessary delay. Purchaser may serve upon the vendor a notice limiting time of expiry of which they will treat the contract as an end. In the present case, the applicant number 1 and 2 has served no notice by their letter so and so to treat the contract as an end. Likewise in my case also. But one more last. This is AIR 2022 Supreme Court. Not it's third judgment.
Third judgment is 1994 Bombay.
It is with regard to 19B. Next judgment. Next judgment. AIR 2022 Supreme Court.
I have 67 Supreme Court, then I have 1990. Next page. You have 1994 Bombay.
No, thereafter, just after that. After this judgment.
What's the name of the party?
AIR 2022 Supreme Court.
Then I have 1921 Bombay again. This is Supreme Court 179. Correct?
Yes, 1793. Yes. Your para number 5.2. May I please read? Considering the fact that the original defendant number 1, the third. Considering the fact that the original defendant number 1, vendor, original owner, admitted execution of the agreement to sell dated 12/4/2005 and even admitted receipt of the substantial advance sale consideration, the learned trial court decreed the suit for specific performance to agreement to sell dated so and so. Once the execution of the agreement to sell and the payment or receipt of the advance substantial sale consideration was admitted by the vendor, thereafter nothing further was required to be proved by the plaintiff. Therefore, as such, the learned trial court rightly decreed the suit for specific performance of the agreement to sell. The High Court was not required to go into the aspect of the execution of the agreement to sell and payment receipt of the substantial sale consideration. Once the vendor had specifically admitted the execution of the agreement to sell and receipt of the advance sale consideration, thereafter no further evidence proof is required. In my case, I have paid 22,000. The substantial has not been proved.
What is the percentage? What is the percentage have you paid out of? Your entire consideration amount was?
27,500.
So how much percentage have you put?
The substantial has been paid.
Substantial मतलब कुछ substantial percentage बताइए.
80%.
80%, right. You see, substantial किसको बोलते हैं? Substantial is a relative word. ये जिस केस की आप बात कर रहे हैं उसमें 29 lakhs was a total consideration, 26 lakhs was already paid.
Hmm. 29 lakhs was total consideration.
And 26 was paid.
There was also 90% around. And more closer mirror. I paid 80%.
So what do you want?
I want to say that the substantial amount of the consideration was paid.
The
First,
point is
the point is
that
that
it was never your case.
the execution with respect time is the essence of what I am confining to right
Yes.
respect.
That's
But they have never given any notice that the contract has been terminated. Defendant never given any notice. Not defendant turned into the witness box, dispute this proposition. I have not paid any amount. Not whether time was the essence of contract or not. Now, my lord, it is a defendant number 2 and 3 was stating that time was the essence of contract.
defendant number 2 and 3 are raising the issue that the time is the essence of contract.
Yes, they are.
They are not raising anything because that was not the issue. They never joined issue on that. Defendant number 2 and 3 they never filed any separate written statement. Did they file?
No.
It was a common written statement. A person who is completely denying the agreement, how can he say that the time was the essence of contract? आप उनको बुला के रखिए, हमको ना बदलने लगता है। Anyways, but I'll continue. है ना? ठीक है? I'm still continuing. In case I want to rise, I will rise. The point is, नहीं, अभी आप अपना बहस करो. मेरा ये कहना है कि nobody is raising a point that time is the essence of contract. And we are not going to hold also that time was the essence of contract. How can we hold it like that? So time was not the essence of contract.
Time was not the essence of contract. We have therefore not the substantial amount has been paid. Substantial amount has been paid, Lord. Now, Lord, if the time was not the essence of contract, Lord, then substantial amount has been paid. The remaining amount, Lord, which is required to be paid, will be paid at the time of registration if the suit is decreed.
But the point is that you did not make out a case of that nature. You did not. Your case was you have paid the entire amount.
Yes, I paid my
How
case is.
a new case is being made up?
I have paid, my lord, the consideration amount was paid, my lord, with 22,000 was paid, and remaining amount of 5,000. The remaining amount was also paid, my lord, and thereafter, my lord, I paid, my lord, I was still ready and willing to pay. My lord, although
That is not your
the
case.
agreement to sell, my lord, the son is the witness.
That is not
I
the
paid the
case.
entire consideration amount.
Your specific case
Even-
is that
even-
you paid the entire consideration.
But even, my lord, if lordship so pleases, some penal charges can be imposed as per the judgment, my lord. That can be imposed, my lord, as per the current rate or whatever it is, because I am in possession of the property as on date. Within the periphery of my boundary wall, which I is read in the pleading also, my lord. If lordship pleases, we can make the additional amount also. It's my residential premises where I am residing. And possession was delivered to me. So therefore, my lord, even if time is not the essence of contract, then already we have paid a substantial money. Therefore, Lord, the substantial question of law that whether the plaintiff can be held to be non-suited for not paying the balance of the agreed consideration within the stipulated. Therefore, Lord, I can the suit is well maintainable and can be filed, Lord. Even the time is not. Court could have directed to make the payment, Lord. Trial court could have ought to have directed to make the payment. Remaining 5,500 was not paid. Even assuming, Lord, it was not paid. Exhibit 9 was not considered. Then trial court could have directed, Lord, to pay the remaining amount along with some interest.
So court could have decreed the suit beyond the pleadings of the parties.
You know, because I am ready and willing, I made a specific statement that I am ready and willing to perform. You know.
Your readiness and willingness to perform is not for the payment of balance consideration.
That is not, you know, but my lord, because my specific reading was not, although my lord, the, you know, again I am coming to that, my lord, the son is the witness to the agreement to sell and he is again receiving the amount of 5,000, which is the actual fact. Now, my lord, although my lord, the defendant, he did not turn up in the evidence witness box to dispute this proposition, he would have been entered into witness box, then definitely this would have put to question, my lord. He would have accepted or denied. Earlier, my lord, they were not accepting the agreement also. Initially, my lord, they were not accepting the agreement, but later on, my lord, when the matter was referred to the writing expert, it was proved that yes, the agreement is genuine. And 22,000 amount was also accepted.
We'll hear them on this. Yes, you respond to the substantial question.
The case set up by them, they sought for a degree of specific performance on the backgrounds that there was an agreement to sell. On that background, they sought for that degree. Now, according to them, in terms of that agreement, which is said to be entered between them and the defendant number 1, rupees 22,000 per square.
Just a moment. The agreement is now admitted from your side? Or you still
No, the agreement, because I cannot deviate from so far written statement is concerned.
No. So findings are no.
Now
There is a finding that there was an
now
agreement.
I have to, because so far as deciding the issue of question of law, now I have to go by the findings.
Yes, there is already
Because-
a finding that there was an agreement.
Yes, now I have to go by the findings.
Yes.
And therefore, so far as I am referring to the agreement which is marked Exhibit 1, that said agreement says about 22,000 being paid, the consideration amount decided being 27,500. 5,500 was to be paid within a period of 3 months from the date of agreement, and the registration was to be made within that period of 3 months. That is the terms of the agreement, Exhibit 1, which is filed by them. Now it has come on record, which is before the record. I would refer to their case. It is their specific case in the plaint that they have given 5,500. First statement is that 5,500 received by the defendant number 1 on 15/5/97. They try to make out a case that within 3 months we have given it. Received by defendant number 1. This is there. Then para 4 of the plaint, they say another statement that 5,500 given to defendant number 1, the date comes 15/5/99. There is a variance that comes. Now during, so far this statement, because the plaintiff has to stand on its own leg, he seeks for a degree for a specific performance. What they have pleaded, that they have to prove, independent of our rebuttal or whatever it may be. First, they have to come out with a case. That is a case falling within definition of section 16 of the specific relief act. If required, section 19 may come into play when the sale is done. Now, they do not tender any evidence to show payment receiving of 5,500 by defendant number 1. Not a single receipt of receiving, nothing is.
That was not their case at the stage of evidence.
Yes, it is not their case, because what they have
We have noted that.
yes,
The order was uploaded yesterday.
yes. Evidence has to be in consonance with the plaint. So, para 3 of their plaint is not proved, received by defendant number 1. Para 4 is also not proved. Now, during evidence, they produce a cheat, Exhibit 9. That cheat which was sought to be heavily reliant.
No, no, you have not read yesterday's order. हम जाते समय 8:30 बजे अपलोड करके गए। आपकी आप लोग पढ़ लीजिएगा। वो सारा कुछ तो हो गया
हाँ
कहानी।
ठीक है वो हो गया।
वो नहीं है।
हाँ
Admittedly, the amount of balance consideration was not paid.
yes, that could not be proved.
That is an admitted position,
Yes,
which
yes, sir.
nobody can
Yes,
deny
sir,
as
I'm-
of now.
Yes, yes, I'm leaving aside that there is no need. Now, they could not prove this. So, if they could not prove this payment of balance consideration amount, and when the agreement specifically stipulates, because the law says section 55 with aid of section 55 of the Indian Contract Act, time would be the essence of the contract if it is specified, and time would not be the essence of contract for an immovable property for the purpose of transaction of immovable property unless it is specified. So here it is a specification in the agreement.
No, in the agreement it is not stipulated that time would be the essence of
No,
contract.
that is not required to be.
No,
understood.
this is the judgment he has
No,
read.
I would rely upon the judgments.
Yes.
This, I would rely upon the
This
judgments.
is exactly what he has read from the
Those,
judgments.
those, I will just try to meet with those
No,
judgments.
we come to that.
Yes, we'll try to get those judgments 77. Now, I would refer to judgments which says in consonance with section 55, because section 55 contract is the basic law. That has to be considered, and the judgments are based on interpretation of the section 55 based on the facts of each case. Now, our case, the agreement, it says the language of the agreement, I just placing it exhibit 1. After the particulars of the parties to the agreement and the nature of the document and all these things,
This agreement says
para 3
para 4.
and
Para 4.
4, and before that,
लेकिन बात खत्म होने के हो जाने मैयाद को लेखाकारी रुपया लेने वो रजिस्ट्री करने को पायबल नहीं होंगे।
नहीं हो. लेखाकारी is the seller, different number 1.
कि after the time you will not be bound to
Yes.
execute the
Yes,
sale.
yes. Then clause 3 and clause 4 read together. This clearly shows there being a outer timeline, and then 4 further specifies. 3 and 4 read together shows that there is a specific stipulation, and in view of this specific stipulation,
और आगे पढ़िए लेकिन अंदर मैयाद के लेखादारी रुपया
लेखादारी को देंगे, वो लेखादारी रुपया लेने वो रजिस्ट्री करने से इनकार करे तो लेखादारी को अधिकार होगा कि अदालत में 5500 रुपया जमा करके अदालत में अनुबंध रजिस्ट्री कराने. This is the situation when the 5500 rupees would be paid within the time stipulated, time period of 3 months, and in that event, if that amount is paid within the
to the court also, and then he can get it executed through the process.
Yes, if despite payment of that amount.
No, if he refuses payment.
No, that is not the.
नहीं, इनकार करे तो लेखाधारी को अधिकार होगा कि अदालत में 5500 जमा करा के अदालत से कानूनन रजिस्ट्री करा ले.
यहाँ से देखिए वो नहीं है लैंग्वेज. लेकिन अगर फैयाद के लेखादारी रुपया लेके दे वह that is within the time period.
वो रुपया लेने वो रजिस्ट्री से इनकार करेगा. मतलब वो दे, मतलब he is offering the balance consideration amount, but the seller refuses to accept that amount and register the property.
Yes.
Then it will be open to him to deposit the amount in the court and get it registered through the process of court.
After, so if this letting is that, then in such view of the case, the plaintiff, it is not their case,
It is not their case at all. They
Ah.
say that the entire consideration was
has
paid.
been paid. So these
What is the consequence under such circumstances? You see, in a case for specific performance, where the plaintiff claims that the entire consideration has been paid and he is seeking specific performance, but at least 80% of it is proved to have been paid, can he still be entitled for a specific performance?
no.
No, ऐसा no बोलने से तो no तो answer करना पड़ेगा
Yes,
ना?
yes, yes. Therefore I am submitting.
No बोलने से
Because
no yes से तो नहीं
हाँ,
चलेगा.
it cannot be done because the law is, so far as specific relief act section 16 is concerned, the decree is sought for in terms of the specific relief act. The law provides for a remedy in such a situation. Section 16.
Specific.
Section 10, chapter 2. Cases in which specific performance of contract enforceable, except as otherwise provided in this chapter, the specific performance of contract may, in the discretion of the court, be enforced. Where there exists no standard for ascertaining actual damage caused within a Performance Act to done, when the act agrees that's compensation in terms for it not afford adequate relief, explanation, and unless and until the contrary is proved, the courts have presumed that the breach of contract to transfer cannot be adequately relieved by compensation in money. That the breach of contract to transfer, it is for movable property. So this section 10 gives the cause of action in such a case, and then section 16 plays a role because it is the exception which is mentioned, section 10, except as otherwise provided in this chapter. So after this, 11 is with regard to trusts, and then 12 is about part of the contract, because it says, 12 says, except as otherwise hereinafter provided in this section. the
Purana
court-
भी specifically.
Except as otherwise hereinafter provided in this section, the court shall not direct the specific performance of a part of a contract, where a party to a contract per whole of it, but the part of which be left unperformed only a small proportion to the whole in value and admits of compensation in money, the court may at the suit of either party direct the specific performance of so much of the contract as can be performed and award compensation in money for the deficiency. Where a party is unable to hold part of it, the part will be left unperformed, either forms are considerable. So these are the situations where there can be a specific performance of part of a contract, which can be applicable in case of a contract in respect of a like thing which is covered by section 10. And then for the purpose of immovable property, the exceptions. Section 16, personal bars to relief. Specific performance of a contract cannot be enforced in favor of a person.
These are specific bars. We are not
Yes,
bothered about
yes,
it.
but here it 16C assumes so far as that
Who
part.
fails to ever and prove.
Yes, two part. One is readiness and another is willingness. That is one part. 16C. So
He has
now
performed and he is always willing.
ready.
to. His case was that he has already performed.
So here he has already performed. So he has get a case.
So far as payment is concerned.
He has set up a case. Now, in such view of the matter, so far as the plea of part performance, now the plea which they are trying to take at this second appellate stage, without any amendment in the plaint at any stage, that now their case would be what they are submitting, what they are making prayer. Their case would be that we have made part performance, we are ready for remaining performance. That cannot be accepted at this stage in view of their pleadings,
That will be a completely new case.
new
for
case,
them.
pleadings and evidences which they have set up.
Therefore, the so far as payment aspect is concerned, not only readiness and willingness would have to be proved, would have to be averred, but is also required to be proved.
Yes.
So now they cannot take a U-turn and say that now the plaint has to be seen as if we were ready and willing to perform this part of the contract by making payment of the balance consideration amount. Because balance consideration amount by itself is a huge thing.
Yes. Yes. Because there is no such provision under the statutes, and the cases which has been relied within 1977, where time was taken to be not the essence. What happened there? 24th May was the end date. 25th May they do a registration of the contract. That shows that the parties did not intend to give effect to that previous time limit. 24 को खत्म हो रहा, 25 को रजिस्ट्री कर लिया, मतलब कि नहीं हमको कॉन्ट्रैक्ट को चलाना है. That was the major deciding factor.
No other case will be taken up.
77, totally different fact. That was the attending circumstances. To show that basically it was a time extension.
Okay, what else? You want to cite some judgment?
Yes, yes. And the other two judgments which they say, the last one which they say about substantial 80% payment, there the facts are totally different from the present case. There it was not the case. It was not their case that we have paid and then subsequently they could not prove.
Yeah.
And then it is not their case. In that background,
There is in none of the cases he has cited, it was a case that they averred something and they could not prove.
yes, yes.
It is not
No,
that.
therefore those cases are on those backgrounds. And here the plaintiff is trying to make out a case which he did not set up, who did not ever sought to prove. Had they ever make out such a case, then those judgments might have been
But
equitable.
you see, this is something. These are the contours which are beyond the substantial question of law.
Yes, yes.
The point is that whether the plaintiff can be held to be non-suited for not paying the balance of agreed amount of consideration within stipulated time, right? Although there is a finding that he did not make the balance
Yes,
consideration
yes.
without stipulated time.
And
Though there is no finding of the courts below that time was the essence of the contract.
here, let's if I break up it. If we break this question of law and if as this honorable court has to answer this,
Yes, we have
and
to
the
answer it.
answer has to be
Rather,
given,
I feel that this question of law does not, in fact, arise for consideration.
because it has
But still, I have to answer it.
perhaps it has been framed in that notion that it was their case that they could not make payment of the balance amount within the time limited.
Yes,
way.
that is not the case.
Yes, otherwise that is not the case, and so there
That is not the case.
and so therefore our reply to this question of law would be that since in the factual background they never came out with a case that we could not pay or we intended to pay and they did not take it.
Take it. That
this
is not
honorable
their
court-
case.
Yes,
Not their case at
which
all.
this honorable court has pointed from clause 4. In the event he pays and I refuse, then
The amount has to be immediately deposited in the court and get it
Yes,
registered
yes.
through the process of.
yes, second part of clause 4.
Yes, it is not saying that as per the order it will be done. The amount, the rebalance amount was to be paid and deposited in the court.
Yes, when it will be refusal from my part.
Refusal, it
Yes.
means that they are so serious about the execution of the agreement
Yes,
and the execution of the sale deed and the remaining balance amount. But the point here is that how does this question of law arise for consideration in this case?
in view of the facts, admitted facts or the pleadings of the parties, our reply would be that there is the question of non-suiting because of non-paying the balance, because it is not a case of non-paying the balance, it is a case of their
You see, let us read non-paying the balance of agreed consideration amount within stipulated time. This
Yes.
is one phrase.
yes, Yes.
It is in continuity, we cannot even break it.
No.
Non-payment of balance consideration within stipulated time.
Yes.
It is nobody's case, non-payment of balance consideration within stipulated time. So, तो कोई case ही नहीं है.
It
If
is
time is essence, not essence, how does that make a difference?
in the factual background. This question would be replied by us in the manner that they were rightly non-suited because they failed to prove their case that they have paid the amount as pleaded by them.
That's
Yes.
at
That-
best.
Yes. Yes.
Now to the second substantial question of yes, please. If you want to respond to this, you
And
may.
judgments will.
You want to cite judgment? Yes, sir. Please cite it. Let him complete.
The Honorable Constitution Bench judgment.
बुला रहे मतलब हम उनको बोले थे पूरे समय यहाँ बैठने के लिए अभी बुलाए तो क्या होगा कल ही बोले थे हम उनको बुलाइए यस
Yes. 2000. This paragraph. This has also considered 1977,
yes
which was relied.
which
by-
paragraph are you reading?
Paragraph 23 onwards, where a previous law has been approved, quoted with approval, paragraph 23. The law is well settled that in transactions of sale of movable properties, time is not the essence of contract. For this proposition, reliance was placed on Govind Prasad, para 24 Chaturvedi case. Then para 25, from an analysis of above case law, it is clear that in the case of sale of immovable property, there is no presumption as to time being the essence of contract. Even if it is not it is important, not the essence of the contract, the court may infer that it is to be performed in a reasonable time if the conditions are evident. Number one, from the express terms of the contract, which is our case. From the express terms of the contract. Number two, from the nature of the property and from the surrounding circumstances. For example, the object of making the contract. So this is in relation to.
So there is not a complete bar that
Yes.
it will never be that.
Yes.
That is he never
Yes.
argued that.
Yes.
He never argued that way. He never argued that it can never be.
But basically,
Generally, it cannot be assumed that time would be
it was
less
since
of contract.
77 they were referring, and 77
That's
was saying that.
Very
So 77 has been considered, and the Honorable Constitution Bench has said that this can be the condition where it can be. This is also same proposition law. I should not repeat that. It only says, I'm just reading one paragraph. 24. The landed council relied reason so and so. A case Vidyanar and Vairanavan. Para 10, 11, 13 for the proposition that courts in India have consistently held that in case of agreement of sale relating to movable property, time is not the essence of contract unless specifically provided to that effect. And the period of limitation is.
Which is the citation?
Yes, I'm just giving. We have 2024, volume 3 SCC, page 230.
230.
232. We are just giving a copy. We'll just hand it. 2024.
So that's all.
volume-
So far as first one
Yes,
is
yes,
concerned,
first question.
come to the second.
Kindly take constitutional bench judgment again. Paragraph 27.
Three elements are given.
Paragraph 27.
27.
then comes the question as to the payment of rupees 98,000. The question is that as to what was the meaning of the word within a period of 10 days only. Here, what is only? Does this apply to the amount of time limit of this 10 days from August 26, 1971? The trial court was of the view that only was meant to stress and qualify the amount of rupees 98,000 and not to be read and mean as if the payment of rupees 10 days was an essence of contract. On this aspect, the appellate court takes into the contrary view and holds that the amount of rupees 98,000 ought not to have been paid on or before 6 September 1971. Failure to do so would constitute breach committed by the defendant. We are of the considered view that the division bench is right in its conclusion. As rightly pointed out in the judgment under appeal, the word only has been used twice over to qualify to be of the 98,000 and to qualify 10 days, 28. Therefore, we are qualified. Having qualified the amount. There was no further need to qualify the same unless the intention of the parties to bring the time essence of contract. Time number 29, reading the last 4 lines more. Therefore, we conclude that though the general proposition time is not the essence of contract, in the case of sale of human property, yet the parties intend to bring time essence of contract to suit a specific performance for the point to it. Again, the same thing will be repeated.
Ultimately, the court held that time was the essence
Time was
of
the
contract.
word.
It has to be interpreted from the agreement.
Yes,
So-
yes, exactly.
Here, marriage is mentioned in the agreement. This is
Yes.
one. The second is that time period of 3 months is given clearly. The third is that if you are willing to pay the amount and if he is refusing to accept it, you have to go and deposit it in the
I mean, responding to each and the date of marriage has not been mentioned in the agreement.
that you have already
Only
said.
purpose,
That you have already said.
second they have not given any notice that the defendant member have not given any notice that the
No.
agreement.
No.
Lord,
Notice is not a sine qua non to make an agreement essence of contract.
Yes, and you
It's
have
a
the reading
constitutional
one line of the
judgment.
agreement.
Yes.
लेकिन बात खत्म होने के बाद न्यायाधीश लेखाकारी पैसा लेने को रजिस्ट्री करने के पाबंद नहीं होंगे, लेकिन अंदर न्यायाधीश लेखाकारी रुपया लेखाकारी को देने और लेखाकारी रुपया लेने में रजिस्ट्री से इनकार करें तो लेखाकारी अधिकार होगा कि अदालत में 1,400 रुपए अदा कर देंगे. मतलब देखो मतलब टाइम वाज गिवन देन टाइम वाज नॉट द एसेंस. लोग कहते हैं अब नहीं लेंगे पैसा.
हाँ, नहीं लेंगे तो आप कोर्ट में जाके जमा कर दीजिए.
मतलब then
And then
this
you
means
will
time is not the essence of
you will
contract.
get it registered through the process.
So this means the time is again not the essence of contract. That's it for the issue number 1.
And what about issue number 2?
Issue number 2. Whether they are bona fide purchaser or not, in the written statement, they have pleaded place number 21. I claim that I'm in possession of the property and there is a violation of the deed notice. Therefore, they were well acquainted that there was a prior agreement to sell, and despite of the fact they have purchased the property. Trial number 21 of the defendant WS says that thus defendant number 2 and 3 are bona fide purchasers and in good faith purchased suit land for a value and price paid to the defendant number 1 without prior notice and knowledge alleged of the agreement and contract for sale of the suit land between plaintiff and defendant number 1. Plaintiff never put and came in possession of the suit land in any manner whatsoever, and the allegations to the contrary are totally false, fabricated, and hereby denied. Lord, they have not taken personal care not to visit the site, not to peruse whether who is in possession of the property. Lord, yesterday I was citing Lord one authority. Now Lord, I'm just citing Lord
71.
but 1994 Bombay. 2000 yesterday I not cited.
No.
I'm not repeating.
Deed
again.
notice is very clear. Why do you need to
Just
cite Bombay?
because this is important. It's a
Which one? Which is important?
Lord, yeah, 1984 Bombay. Directly I read this exact word paragraph. Not sir,
On
once
this-
argued, you can discuss the party and not with respect to this team notice.
This is Upadhyay.
They
J.
have the-
Upadhyay.
Yes. Ma'am. For the first time, I learned about what is section 3. Ma'am. Then they have their journey also. Yes, ma'am. For the first time, I got to know what is section 3. Several times during our
From there, we say the principal buyer we have it. That.
Anyways, one is AIR 2000 Supreme Court 292
that I placed not yesterday.
that you
now
have
I'm
placed
taking
yesterday. Now you want to place
94 Bombay.
94 Bombay. You have
Third.
placed it again in this set or not?
Yes, ma'am.
94
Just to
Bombay.
compile not even this.
Yes, 1994 Bombay.
That is page number 369.
Next, which paragraph do you want to?
Your second column, 8th line. Then in noted worker starts number, a person
It
is
is
set
at 369.
369, second column.
No, it starts from 358.
No, it starts
AIR 1994 Bombay
358, yes,
358. So you are
369.
you are referring to page number 369.
369.
Yes.
Your second column, 8th line. Top. It starts from inverted comma. A person is said to have notice when he actually knows the fact or when, but for willful abstain from an inquiry or search which he ought to have made, or gross negligence, he would have known it. It is so stated in section 3 of Transfer of Property Act, explanation 2, appended in the said relevant provision read as explanation 2. Any point acquiring any immovable property or any share or interest in any such property shall be deemed to have notice of the title, if any, of any person who is for the time being in actual possession thereof. Explanation 2 was incorporated. Explanation 2 was incorporated in the Transfer of Property Act by amending 1929 Act of 1929. I shall now refer to the third illustration to section 27B of the Specific Relief Act 1877, which has been relied by the learned counsel for the appellant, which with considerable force. The said statutory illustration to the old Act 1977 Act reads as follows. As under. B. The A contracts to sell land to B for rupees 5,000. B takes possession of the land. After A sells it to C for rupees 6,000, C makes no inquiry of B relating to his possession of the land. B's possession is sufficient to affect C with a notice of his interest, and he may enforce specific performance of contract against C. The material portion of section 27 of Specific Relief Act is identical to section 19 of the Specific Relief Act 1963. The statutory illustration appended to Specific Relief Act 1977 do not form the part of Specific Relief Act 1963. Still, the reference can be made to the statutory illustration for the purpose understanding the legislative history of the Act and the background of the relevant provisions. In this view of the matter and in view of the findings that the plaintiff was in actual possession of the suit land since 14 February 1966, I have no hesitation in holding that the defendant number 3 has constructive notice in respect of the suit agreement, and the said agreement is enforceable against the defendant number 3 also. Defendant number 3 ought to have made necessary inquiry in respect of the possession of the suit land by going to the site from the neighboring landowners, which defendant number 3 failed to do. Actual possession of the suit land with prior purchaser operates as a constructive notice of the original agreement to the subsequent purchaser. Defendant number 3 cannot be bona fide, cannot considered as bona fide transferee for value without notice. It is therefore not necessary to examine further questions as to whether defendant number 3 was guilty of mere negligence or gross negligence in respect of his obligation to make necessary inquiry in the matter, and as to whether the defendant number 3 should be deemed to have notice to the plaintiff's agreement before arriving to the impugn transaction on this count also. Here I come to the conclusion, not that he does not make any personal research, not whether who was in possession of the defendant number 1 is in possession, whether the plaintiff is in possession.
That's you read it for me.
Sorry.
आगे भी पढ़ना.
The learned counsel for the appellant has further submitted that defendant number 3 cannot avail the exception to section 19B in view of the admitted fact that defendant number 3 had retained part of consideration amount for discharge liability of the vendor. The learned counsel for the appellant has relied upon the passage from so and so.
वो passage भी पढ़ी.
The entire money or the equivalent thereof must have been paid. If the subsequent purchaser retains money to be paid to the third person in discharge of his debt but remains unpaid, the money has not been paid.
The subsequent purchaser has retained that money, then money cannot be said to have been paid.
Yes.
So it is nobody's case here that
Yes.
the amount was not paid by virtue of
That's
registration.
the first paragraph of the
In one judgment, I have held that under section 16C, if a person wants to get the benefit, then the entire constitution amount should be paid already. I've held it, but I will still not rely upon that because that is subject is notice has been issued. So I will not rely on that. As I remember that some notice has been issued in that judge, but I'm not sure. Mr. Banerjee, you were only appearing in that case. In an old case where Mr. Shashank, you were appearing. कोई तो काफी देर लड़ाई चल रही थी.
That was with respect to when RN Sai was appearing, that side Rahul Sai was there and Ayush Bhaiya was also there.
Yes, RN sir.
Yes,
That is, I think, subject.
Yes.
That is subject.
yes.
Are you sure that it is
Yes.
subject?
I'm not sure, but that was the judgment your lordship is referring to.
Yes.
That is the reported judgment 2025 volume 1 lot of JBC.
उसको पूछ के निकालिए. उसमें कुछ डील किए थे हमको याद नहीं है. कोई ऐसा क्या?
That is second appeal number 78 of 1999.
ऐसे 78
Of 1998. That is dated on 25th August 2025.
इसका सॉफ्ट कॉपी चाहिए. ठीक है. Anyways,
On this point, the lordship permits the
that's all. What other?
legal counsel is also there in that.
That's right. Constructive notice, there is no doubt. A person who is there on the spot, one has to make inquiry. There is a constructive notice that he is in possession. So a buyer has to, if you want to buy a house and somebody is already there, so before buying, will you not go and ask him, are you the owner of the house or you are just a tenant or whatever you are?
Regarding this, they have not made any research. They found out the finding of the appellate court in this regard that I am not in possession, so that is perverse.
That portion, because only on statement he has said he has not taken note of the fact
Yes.
that you were in possession. Is there any finding that you were in possession? Because of that pleader commissioner.
Yes, but it is fine.
Exhibit. That's all. What do you say?
Yes. So for this issue is concerned.
Constructive notice.
Yes.
And where is that judgment of mine? उनको याद है क्या?
That bar matter on the Gita Devi.
गीता जी. इतना लड़ाई की कुछ कहने का नहीं. जज साहब सुप्रीम कोर्ट गया था, वहां जाके लोग कॉम्प्रोमाइज कर दिए. उनको बड़ा अफसोस हुआ. बोले इतना मेहनत करके आपको ऑर्डर किया, आप अपलोड नहीं कराए. लेकिन अच्छा हुआ compromise हो गया, it's good.
I assisted from that side a lot. Along with IB, I was appearing. From I got to learn at that point. For the first time, I got to know what is section 3.
अच्छा,
So the second question of law is in favor. I'm reading from para 16 of the previous day order of dissolved. Whether the first appellate court has misdirected itself in law deciding the issue of bona fide purchaser under section 19B of a specific relief act by shifting the burden of proof upon the plaintiff without the defendant first discharging their initial burden of proving that they were transferring with value in good faith and without notice. So before answering this question, the first crucial point is that no relief has been, as today also, this honorable court put a question as to whether the sale deed has been assailed or not. There
no,
is-
that need not be assailed.
no, there is
No, there is a judgment also.
there is one.
No, the law is well settled. Law is well settled by
Hmm.
constitutional bench judgment that it need not be challenged. Only making him a party and asking him to join as co-vendor is more than sufficient. He need not join. For subsequent purchasing, there is no need to challenge the same.
And just for a moment, two paragraphs of this para 910. It has considered 17A Registration Act, 53A Transfer of Property Act, because part performance, whenever it would be with help of 53. It has considered and it has said that in such a suit,
You see, we are not on that point. Please don't digress from the point of law. I will only confine myself to the point of law. You have not filed any petition that this is also a substantial question of law.
I'm
So
only
we are
saying
not bothered
for the
about it.
purpose of, and just
No, not academic. We are not interested in
academic,
any
just-
academic discussion.
Just allow 2 minutes. I'm just trying to say something. I may be not starting it in that manner, so there may be a misconception of the code that I'm saying something else.
Yeah.
It is in reference to this question of law. Now, this question of law, what is this question of law? This is a reference from section 19 of the Transfer of Property Act.
That's right.
19B says, 19B is further, it says about whether 19 is relief against parties and persons claiming under them by subsequent title. Thus, heading itself, relief against parties and persons claiming under them by subsequent title. So it says about relief against. And therefore, I am saying though relief has been sought for, it is not only hit by section 19, it is also hit by section 34 of the specific relief act.
No, relief has been sought. Prayed qua all the defendants.
The relief is
Qua
Is-
all the defendants.
is for specific performance on
No.
basis of the agreement.
No, you just
Because-
have a look at it. The relief is against the defendants
Relief
to
is a-
execute the sale deed.
now the nature of relief to execute the sale deed. Now the implication of the previously, now there will come into play the Transfer of Property Act where two sale deeds are there. What will be the effect of the subsequent sale deed? Transfer of Property Act says subsequent sale deed would have no value in IFR.
Just a moment, that is why the court would direct all the defendants to join together to execute the sale,
Even then,
including the earlier purchaser.
it is a broader question. I am saying so why it has a implication. Although even if नहीं इसका implication हम इसलिए ऐसे बता रहे हैं, इसको हम लोग ऐसे ले एक रजिस्टर्ड डीड हो गया. सेक्शन 19 क्या बोल रहा है कि रिलीफ आप उनके अगेंस्ट में सब्सिक्वेंट परचेजर जो उसके सूस में स्टेप कर रहे हैं उनके अगेंस्ट.
Subsequent purchaser is a party and the relief is against all the defendants.
Now a situation if there are two sellers, that sale deed will
भाई
stand.
देखिए, I'll tell you one thing. This argument is age old. Since 1960 से ये सब argument चल रहा था, and then one judgment was passed in 1970, some Prashad, and thereafter it was referred, and then there was a judgment Durga Prashad.
Which is referred in this.
Yes. Durga Prashad.
Yes.
And thereafter a subsequent judgment was passed contrary to Durga Prashad, and then it was found that the Durga Prashad was not noticed. It was sent to a larger bench, and then the matter has been.
Yes, that is the issue of the ratio on the issue of burden of
We
proof.
are not here.
Burden of proof.
No, that is not on burden of proof.
in so far as 19B is concerned.
Durga Prasad story is not on burden of proof, but our substantial question of law is on burden of proof. So
No.
you confine yourself. Were they in possession of the property or not? Yes or no?
No.
Then how do you explain the pleader commissioner's evidence that it was they
Who produced the key?
who produced the key, opened the lock, and allowed the party
That,
to get
that does not imply the possessor. Opening the lock and key, that does not shows the possessor.
That shows physical possession. In a constructed house, a person is opening the lock and entering the premises. You say it is not possession.
Even
Mutation will be possession.
because
No.
giving a lock and key, that cannot be implied possession.
It is not implied possession. It is actual physical
It is-
possession.
because
A
it is-
person who is in control over the property by virtue of a lock and key, he is in physical possession of the property.
but there should be attending facts and proper findings. Possession.
No.
Possession is an act. Possession is an act.
They
Act of
claimed,
enjoying the
just
property.
a moment, they claimed that they were put in possession. Right? You denied everything. What is there in both the judgments which says that they were never put in possession?
Just allow me 2 minutes. Just allow me. I will answer the questions. A few things which I have made in my mind, which I should just convey to this honorable court. First of all, possession issue. The contract, the agreement, Exhibit 1. Exhibit 1 does not says that after the part performance, possession is handed over. It is not there. हम ये बोलना चाह रहे हैं कि एग्रीमेंट में ये नहीं लिखा हुआ है कि पार्ट परफॉर्मेंस के साथ दखल दे दिए. Had it been so, then we would have a weaker case on so far as this part is concerned.
उसमें लिखा हुआ है इनके प्लेंट में कि remaining
Oh,
balance
it is their assertion.
consideration के बाद. It is their assertion.
Which they conduct. उनका assertion क्या है? In token of part performance. तब तो वो contract में होना चाहिए था. It should have been in the contract. वो जो language है छोटा सा कि आज लेने के बाद इनको दखल देती जो रजिस्टर्ड में रहता है. पार्ट परफॉर्मेंस जब भी होगा उसलिए हम 2018 दिखा रहे थे. 53A का 8 से ही होगा and 17(1)A registration act will come into play with 2018 has taken. And in other way, before the honorable court
17A. That is the
registration act.
I understand that. Agreement कब का है?
This agreement is of 1997.
1997. Was that amended portion applicable? 2001 में हुआ amendment. That amendment is 2001. That in order to claim the relief of part performance pursuant to an agreement of sale, it has to be compulsorily registered.
Agreement does not apply, my lord.
It does not apply.
Section 34 of the registry itself says that does not the exception to special relief act.
This honorable court is correct. It has applied from 2001.
2001.
Applied from 2001.
So prior to that, you see, agreement of sale by itself does not transfer any property. Firstly, therefore, it is not compulsorily registered. It can be enforced even as of now
Yes.
by way of specific performance of contract. But if a person claims part performance
Then it
and
has to be-
claims the protection of 53E
Yeah.
post 2001, that agreement of sale is required to be compulsorily registered.
Correct. Just allow.
And prior to that, even that agreement of sale was not required to be registered.
Ah.
53A protection was available to the party.
53A.
Yes, that is part performance.
Yes, 53A. Now, if we leave this, if we leave this 17(1)A, and so far as
So you come to the point.
yes, I am coming to the point. Part performance. This is on burden of proof.
Yes,
this is on burden of proof. Now, on burden of proof, I will just straight away to the facts of this case. The written statement filed by us.
No, not on the facts. Now you come to the finding. Impugned judgment ना ये पढ़े हैं ना आप पढ़े हैं आप पढ़े.
नहीं, एक बार वो देख लीजिए तब जाने इस पर. खाली एक बार स्टेटमेंट मेरा देख लीजिए. उसके बाद उसमें जाना. Para 19. Para 19 of our written statement. at that first instance, different number made a proposal to sell the soup land to 2 and 3, which they also accepted. And in negotiation, the total price of total soup land was fixed so and so, and different number so and so by means of two different registered sale deeds number so and so, each having so and so area, getting consideration amount, and put and delivered in possession of the same to the different number 2 and 3 on the same day of the execution of the registered sale deed. And since the different number 2 and 3 has been coming in principal possession over the same by exercising all acts of possession thereon, all acts of possession there with full knowledge of the plaintiff and all concerned, surrounded by compound or so on. Then para 20, because it is the burden of 2 and 3. 19b what says, different 2 and 3 have purchased the soup land and given the valuable consideration amount of rupees 38,000, having paid by them rupees 19,000 before the execution of the sale deeds to the defendant number 1, and without prior knowledge of alleged agreement between the plaintiff and the defendant number 1, and the alleged agreement agreement that has been created. So here, just I was intending to show this, that we set up a specific defense.
That's right.
Specific
Did you prove it?
Now, when we have set up a specific defense, we have said this. Now the owner shifts to them.
No, it is not like that. You see, your mere denial is their denial is that you are not in possession. Right? You denied that they are not in possession and you are in possession.
But either both the parties disputes each other contents. They say we are in possession, we say we are in possession.
That's right.
Yes. And now after this,
And pleader commissioner says that they are in possession.
that and they gave the key to me, opened the lock in front of me. Now one more thing. Even if suppose if
It is your residential house. It is their residential house.
it has not come, nothing has come on record. So
Where
it
do
will
you
be,
get this? That it is your residential house and you must be having electricity connection, water connection, what all not for a residential house.
That is from the building commissioner's report, I opened the door, and leave the lodgement.
That is a separate thing. Otherwise, those electricity connection, water connection, everything is not there.
Because they, along with the I read one paragraph.
it is not in the plate. It is not in
I
the
have read
plate.
one paragraph from the plate, along with this property, there are other properties also within me.
Which you amalgamate.
It is not
Yes,
in the
ma'am.
plane that it is a dwelling house or something like that. It is not. And one thing finally, even if it is found by this honorable court that the learned courts below have erred in applying the principles of burden of proof and by shifting the onus on them without we primarily discharging a duty, then also the answer, if it is given against us, so the answer will be that we are not a bona fide purchaser. But it will not make a difference to the basic finding of the suit, because they have sought for a relief or suit for specific performance. They have to show their entitlement in view of the answer to the first question. If it is ultimately found that they have failed to discharge their burden while answering the first question, and so they cannot maintain a suit for specific performance, or they have failed to prove their case, then the second question, despite the answer of the second question being against different number 2 and 3, then also the suit would fail. It would be upward so far as the dismissal of the suit by the first court is concerned. That is one thing which I just wanted.
That I can see that. I can see that, and I am telling you right from the beginning yesterday. I can see that. That's all.
One thing was just, para number 6 of the plate I stated that the other properties have constructed a house. Reading that the plaintiff after coming in possession of the same land.
That's
And so far as possession is concerned, they have not proved even the mutation in their favor. As on date also.
It is not nowhere their case. We cannot make a submission which is not on record. We should not make a submission beyond records.
My lords was correct, in that case, the Supreme Court has issued notice.
I'm right.
Yes,
5th
of January.
leave granted. Leave granted.
Not the leave granted.
Not yet
The
granted.
notice have been issued.
Whose substitution पे notice है?
No, only notice have been issued to parties.
ऑर्डर में जो
You have shared with this.
उनको प्रिंट दीजिए सेकेंड अपील के ऑर्डर्स का ट्रैक रखना पड़ता है कुछ भी फॉलो करने के पहले आई शुड बी श्योर व्हाट आई एम फॉलोइंग
My Lord, Lordship, I remember me not that particular case, my Lord, and it is an issue. I also know I have gone through the full text of that judgment, my Lord, but I have not cross-checked the.
जब तक हम अपना जजमेंट को क्रॉस चेक नहीं कर लेते हम ऐसे कोई जजमेंट फॉलो नहीं करते एक ही रेशियो को हम 10 जजमेंट में 10 बार डिसाइड करते हैं फॉलो करके तब तक नहीं डिसाइड करते जब तक वो सेटल नहीं दैट इज अनलेस आई नो दैट इट हैज नाउ सेटल्ड ऐसे नहीं फॉलो क्या जरूरत है अपने जजमेंट को फॉलो करते रहना नॉट रिक्वायर्ड अपने कर दिए एक बार बहुत है कितना और एक ही चीज को करते हैं
I'm giving the copy which I cited 2024 one.
लिखिए तो both the parties have extensively advanced their argument on both the substantial questions of law involved in this case. The learned counsel for the appellant, by referring to the first substantial question of law, has submitted that without any issue as to whether time was the essence of the contract, no such finding could have been given. And therefore, and admittedly in the present case, no issue was framed with regard as to whether time was the essence of contract. Nor any such finding has been recorded by both the courts. However, it is not in dispute that not only the terms and conditions of the agreement, but also the conduct of the parties is required to be seen for ascertaining as to whether the time was the essence of the contract. The learned counsel submits that the time was never the essence of the contract, even if end-to-end date is mentioned in the agreement. The same does not mean that the time would be the essence of the contract unless it is specifically mentioned in the agreement. He submits that it has been mentioned in the agreement that the money was required for the purpose of marriage, but not even the date of marriage was mentioned in the agreement. The learned counsel submits that so far as sale relating to land is concerned, it is to be presumed that the time would not be the essence of the contract unless there is specific clause in the contract. And mere mentioning that time would be the essence by itself may not be sufficient. He has relied upon the judgment passed by the Honorable Supreme Court reported in AIR 1977 SC 1005, AIR 1967 SC 863, AIR 2022 SC 1793, and these judgments have been elaborately placed before us.
They have not, defendant number one have not issued any notices.
Okay, the learned counsel submits that the defendant number one never ever issued any notice that if the appellant would not perform his part of the contract, then the agreement would stand terminated.
After termination of the agreement, he has not even issued any notice that the contract has terminated and now
The learned counsel submits that after the expiry of the period of agreement, the respondent number one never issued any notice that the period of agreement has terminated, and therefore they are not bound by the agreement. The learned counsel for the respondent on the first substantial question of law has submitted that upon true reading of the agreement, it would reflect that time was the essence of the contract. He submits that the purpose for taking money was mentioned and a strict timeline was also provided. It was also provided that if the amount is not, if in case the defendant number one refused to accept the balance consideration amount, then also the amount would be deposited in the court and the agreement could be executed through the process of court. The learned counsel has relied upon the judgment reported in bracket 1993 bracket close 1 SCC 519 para 23 onwards and bracket 2024 bracket close 3 SCC 232. With respect to the second substantial question of law, the learned counsel for the appellant has submitted that it was the specific case of the appellant plaintiff that they were put in possession in part performance of contract. Though it was denied by the defendants, but the pleader commissioner who had inspected the premises was examined before the court, and he had disclosed that it was the appellant who provided the key to the premises in presence of everybody, and then it was opened. The learned counsel submits that this itself indicates that the appellant was in possession of the property.
This report is Exhibit 5.
The report of the pleader commissioner is Exhibit 5, and he was examined as
PW6.
PW6. The learned counsel submits that once this court finds that the appellant, once it was found that the appellant was in possession of the property, then under such circumstances, that amounts to deemed notice under Section 3 of the Transfer of Property Act to all the persons, including the persons who intend to buy. We have submitted that the learned first appellate court has incorrectly recorded that the appellant never took a plea that they were put in possession of the property by way of part performance. Although there is specific plea, and he has referred to the orders passed by this court earlier. The Kalwala, yesterday's order. He has referred to para 3 and 4 of the Act. With respect to deemed notice, the learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in AIR 2000 SC 2921 and also the judgment passed by Honorable Bombay High Court reported in AIR 1994 Bombay 358. That's all.
And our further assertion
Yes,
guidelines.
just
I was only seeing that
Our further assertion, which we made in reply to first question, is that if they have set out a case that they have given the entire money and but
Just-
they have failed to prove that,
just
and so in that manner,
इनका जो submission लिखा है ना उसमें The learned counsel for the respondent has also submitted that the specific case of the plaintiff was that they have paid the entire consideration amount, and what was remaining to be done was only registration. No consideration was remaining to be paid. But the plaintiff has failed to prove that the balance consideration amount to the extent of rupees 5,500 was paid, and there is a specific finding recorded by the learned first appellate court to that effect.
Both the courts. The first court also an issue
by,
number 3.
by both the courts.
On issue number
The learned counsel has submitted that the appellant, the plaintiff has failed to prove his own case, and thereby the plaintiff has failed to prove that he has performed his own part of the contract, and therefore the suit has to fail,
he cannot seek a decree for a specific relief.
and consequently he cannot seek a decree for specific relief. आपका कुछ
Lord, one thing, Lord, that he has not filed any counterclaim regarding seeking recovery or possession in this suit. Lord.
इसका क्या जरूरत है?
Still, I am in possession of the
इसका
property.
कोई जरूरत नहीं. वो
We are
आपका-
saying we are in possession. Where is the question of recovery
We
of
are
possession?
saying we are in possession. You are saying you are in possession. जितना है उसके beyond थोड़ी हम लोग जाएंगे.
If Lordship comes to order 7.7, perhaps holding out relief.
That is also within a parameters, molding of relief, not beyond section
नहीं
34.
हमको अपना second appeal में molding of relief नहीं करना.
Section 34 to beyond जा भी नहीं सकते.
With respect to second substantial question of law, the learned counsel for the respondent has submitted that since the purchaser of the property are in possession and they have specifically pleaded so in the written statement in paragraph number 21, that they were put in possession of the property after execution of the sale deed.
Para 19 and 20.
So the argument of constructive notice to the purchaser of the property as argued by the learned counsel for the appellant is completely misplaced. Correct? यही आपका argument है. Now एक चीज देखिए, इन लोग का argument हो गया conclude. अब चार्ट टू डेट लिखिए 27/4/1997. This is the date of agreement.
Exhibit 1.
Within bracket exhibit 1, rupees 22,000 was paid. 15/5/1997. The plaintiff claims to have paid balance consideration amount to the defendant number 1 to the extent of rupees 5,500.
Exhibit 9.
Sorry,
Exhibit 9.
ये exhibit 9 नहीं बोलेंगे, आपको plain से चलेगा. 26/7/1937. It's 1997. 3 months expired. The cause of action as pleaded in the plaint is last week of October 1999. When the plaintiff approached the defendant number 1 to get the sale deed executed, defendant number 1 refused to execute it on 1/11/1999. Thereafter, on 3/11/1999, the plaintiff sent legal notice, which was served on 6/11/1999, and the 2 sale deeds were executed on 5/11/1999 by defendant number 1 in favor of defendant number 2. Correct? concluded.
Their application for additional evidence has also to be disposed of, otherwise they may take a plea that it is pending.
वो तो already अभी
नहीं, वो
additional
it
evidence
was-
बाकी है.
वो बचा हुआ था ना, उसको there nothing of nothing in the pleading.
तो आइए उसको करें. ऐसे डिस्कस करें.
We have also given a reply, we have contested
This is
that.
on merits, but that there is nothing in the that is beyond pleading. But that is the
क्या है दिखाइए क्या चीज का आइए So far as the additional evidence contained in IA number 2874 of 2026 is concerned, during the course of एक है इसका supplementary application. हाँ भाई हमको to reply yes I do open up the email. क्या चीज आप लगाए हैं सेल डीड ये क्या चीज का सेल डीड लगाए हैं
Different land, no concern with the suit land.
adjacent to suit land or the plain parameters has stated that there is certain other properties owned by me which I amalgamated with the
इस
suit property.
क्या मतलब है भाई मतलब क्या बिल बनाने के लिए सब करते हम लोग तो कर लेते थे कभी क्लाइंट आता था तो बोलते थे अच्छा जो बोलते हैं लगा दो।
As if a right of preemption is named in the suit.
राइट ऑफ प्रीएम्पशन का कहानी है IA number 2874 of 2026. During the course of arguments, the learned counsel for the appellant has completely failed to satisfy this court as to how the additional evidence would be relevant, how the proposed additional evidence would be relevant for the purposes of disposal of the present case. And particularly in view of the fact, also in view of the fact that there is no foundational pleading
Yes.
to that effect. Accordingly, IA is seeking additional evidence as discussed. वो हम करेंगे उसके साथ.
That is beyond pleading.
हाँ, beyond
Beyond.
तो हम उसके मेन जजमेंट के साथ ही करेंगे.
Because additional evidence they have to satisfy either of the three tests. That we produced it, original court did not allow it, it is not their case. Second, that we could not find it or produce it, due diligence. Both the circumstances are not coming. And third is, if this honorable court sees or finds that the document are relevant. So here only the third proviso they can invoke.
देखिए कुछ भी रिजल्ट हो
हाँ,
लेकिन ऐसा कन्वीनियंस कंपाइलेशन रहेगा तो हम आराम से सेकंड अपील डिसाइड कर सकते हैं कोई भी सेकंड अपील डिसाइड कर सकते हैं लेकिन जिस तरह से आप लोग हमको मेहनत कराते हैं ना वो पुराने रिकॉर्ड्स में तब आई जस्ट
we understand that.
यू शुड आल्सो लर्न बहुत अच्छा है इस तरह से मतलब
Once
convenience compilation है ना what all documents a person is relying upon तो आप तो इन्हीं से सीखेंगे हमको क्या बोलना है.
Once the documentation is proper in a file, we can read it
देखिए
properly.
सेकेंड अपील में हमको 2 ही 3 चीज प्लेन रिटन स्टेटमेंट तो आपको जरूर चाहिए क्योंकि जो जजमेंट रहता है ना उसमें बहुत सारी चीजें पता ही नहीं चलती है टाइपोग्राफिकल एरर रहता है डेट्स का एरर रहता है
It is the basic documents. It is
उसके बाद बेसिक डॉक्यूमेंट्स एंड बोथ द चैप्टर्स दैट्स इट ओके आइए डिस्कस नहीं करना अभी नहीं आइए डिस्कस करना है वो एक ही साथ फाइनल जजमेंट